Hello everyone. Welcome to Legal Talks with CS Yatin, where law meets storytelling. In today's case, we will explore how the question of who owns a company shook the British courts during the First World War. It's an exciting case of Daimler Company Limited versus Continental Tyre and Rubber Company Limited of 1916, where the House of Lords address a wartime dilemma. Can a company registered in England be treated as an enemy if its controlling members are German nationals? The Continental Tyre and Rubber Company Limited was a company registered in England, but almost all its shareholders and directors were German nationals residing in Germany. It used to import tires and rubber products from Germany and supply them to British companies like Daimler Company Limited. In 1914, World War I broke out between Britain and Germany. Soon after, Continental Tire sued Daimler Company Limited in England for payment of tires it had delivered earlier. But Daimler Company refused to pay, arguing that Continental Tire was an enemy company because it was controlled by Germans. This led to a powerful question. Can a company incorporated in England be considered as an enemy due to nationality and resident of its shareholders? The lower courts were divided in their decisions, and eventually the matter reached the House of Lords, the highest court of that time. The House of Lords delivered a historic judgment. They held that while a company has separate legal personality, its character in wartime depends on the controlling persons. If its controlling shareholders and directors are enemy alliance, then the company may be treated as an enemy. This case marked an exception to the doctrine of separate legal personality. It laid down that number 1, in times of war, the court may look beyond incorporation. Number 2, a company's enemy character is determined by who controls it. And number 3, protection of national interests may override corporate personality. This judgment has been cited in India to show that separate legal entity is not absolute, especially in times of national emergency, war, or public interest. Under Indian law, courts have used similar reasoning in enemy property cases, FEMA FDI control issues, cases involving beneficial ownership, and shell companies. In summary, Daimler versus Continental Tire case reminds us that the law can look behind the mask of incorporation, especially when the national interest is at stake. It's a key case in both company law and constitutional principles during wartime. If you found this case fascinating, don't forget to like, comment, and subscribe to Legal Talks with CS Yatin. Let's keep exploring the law, one case at a time.